I think we're live. Great. Good afternoon, everybody. I'm Chris Body. This is Paul Morrison. We're from Body and Morrison. Thank you for coming for this afternoon's Plan On It webinar on the wonderful topic of probate. Now, before we get into actually discussing what probate is and how you can potentially avoid it, we've made it available for download. You should see this on your screen, a sample binder. In that binder will be the documents we're going to be talking about today in terms of how to avoid probate. So you're free to download that. It's a PDF file. And as we go through this webinar, we will be referring to some of the documents in there.
Yeah, thanks again, everybody, for taking time out. We're getting some attendees trickling in, it looks like. Thanks for joining. Yeah, as Chris indicated, this is one in a series of occasional daytime webinars we do. It's a little series called Plan On It. As you may as may become obvious, you'll see we're relatively new to the webinar game. Due to COVID, obviously, we had to stop kind of our bread and butter way of spreading the word on estate planning and educating folks about it. Our typical way of doing that was in live workshops hosted. We'd have a good time with it, have some fun. They would stretch out about 2.5 hours. And we fortuitously had videotaped one of those a year and a half or 2 years ago. And so we had it sitting there, and we were able to, when we had to make this pivot from live presentations to web-based, we were able to take that full-blown workshop and condense it down into about a 2-hour presentation, which we now do periodically. I think a couple times a month in the evening. We do about a 7 to 9 o'clock webinar. And that, as I said, is a condensed version of our big full dog and pony show. You can check our website, obviously, for dates of upcoming webinars of that ilk. The daytime ones, the Plan On It series, those are just our way of kind of expanding on a topic, one per session. Today's topic, as Chris said, is probate. We've touched on healthcare directives. I think we had one that focused on that. I think we got one coming up about AB trust, which is a little bit more complex, somewhat wonkish topic, but you're welcome to sit in on any of these. But today we're taking it back kind of to the beginning. And as you may know, there's a couple primary objectives. One is seeking to achieve when one embarks upon estate planning.
You want to talk about the chat feature first?
Oh, yeah, good one. All right, chat feature, good point. As you see on your margin of your screen there, in addition to the ability to download the sample documents that Chris referred to a minute ago, there's a chat function in this thing too. So anytime you guys have a question that comes to mind, enter it into the chat function. I'm not sure. I think we'll just gang them up and deal with them at the end, but maybe we'll just freestyle them as they come in too. So if you have a question, don't be shy. Chat it to us, and we'll address it sooner or later.
So those are private, by the way. If you send a question, it just goes to us directly. The rest of the group does not see it.
But we're gonna restate what the question is when we answer it.
Well, we might. We're not going to discuss it, right? But if it's in the context of what we're discussing, we might just answer it during the actual webinar, because this is a free flow of information here. That's how we want it to be.
And it is. It's our opportunity to kind of drill down into one topic and really hit it pretty hard. As I said, we bounce around on topics, but it's worth checking our website to see what ones are coming up and what the topics are. If they're of interest to you, feel free to join anytime. Okay, so today,
click on the chat button just so we have it open.
Let's see.
Sorry, we're still getting used to this. Okay.
All right. So probate avoidance is one of the most essential objectives that one is seeking to accomplish in preparing an estate plan. And the reason that probate avoidance is so compelling is because probate is so horrible. All right. And probate is the mechanism that our system has put in place, which oversees the transition of assets from a decedent, a person who's passed away, to people who are living. And since dead people can't sign deeds or can't transfer accounts and things like that, the system was created to facilitate an orderly transfer of assets from that deceased person to the people to whom they're supposed to go. Now, there's essentially two fast tracks into probate. The first is if a decedent had done nothing in terms of planning, just went about their life like most busy people, didn't take time out to learn that it wouldn't be a bad idea to do a little planning ahead, and died. Now, in that case, they had no documents, no will, no trust, no nothing. Their assets assuming they had assets that were in their name with no beneficiaries on them at the time that they passed away, those assets must pass through this process known as probate to reach the people to whom they belong. The other way to get oneself or one's estate technically into probate is to try to accomplish that transfer of assets by way of a will. Wills trigger probate. All right. So whether you have a will or no documents, your assets are going to have to pass through probate before they can reach the people who are entitled to them. All right. Now,
That's a pretty common misunderstanding, right? That the
True.
will, right?
Yeah, a lot of people think, well, my people are at risk of having to be subjected to a nightmarish probate process because I set up my will. Incorrect. Okay, it's a popular myth. Many people are going through life with this belief that somehow if they'd had a will when they die, their stuff won't have to go through probate. Incorrect. Okay, probate happens to your stuff whether they had a will or not, and therefore it's really critical for us to understand what probate is, so we really understand why it's really compelling for one to avoid it, which, as I said, is one of the compelling reasons to embark upon estate planning in the first place. All right, so what is probate? Well, it's fun to look back on where it came from, too. Historical note, you may remember this one. As lore has it, and I think this is true, our California probate system was created and enacted in the gold rush days because if a miner died and he had a claim, everybody was going to jump that claim, right? The term jumping the claim. So, claim jumper, Chris's favorite.
No, it's not.
Large portions. All right. So jumping the claim. Well, they had to have a system that would determine who really was entitled to that deceased miner's mining claim. So the system came about, and they have a hierarchy of people that are entitled to receive, which we can touch upon in a few minutes. But over time, obviously, like everything else that's systemic, this thing has become burdened with feature creep and more complications. And the probate discussion is a state-by-state conversation. But we in California, go figure, are blessed with probably the most complex, most convoluted, most dragged out, most expensive probate process of virtually any state that we're aware of. And the things that make probate so horrible, they really start building up on the foundation on which it's based. Probate, okay, it's a formal court proceeding. It's held in Superior Court, Probate Division, but it is essentially a hearing to prove. All right, the word probate means to prove. And so before anyone can inherit from a decedent, they have to prove that they had the right to do that. All right, and so the things that make it horrible are it's a formal court proceeding. If you've ever been involved in any kind of court proceeding, none of those are fun. This one is probably the worst of all. It takes a long time. All right, how long? We always hear horror stories about, celebrities, their probate's taken 15 years. Marlon Brando's is stuck in probate right now. He died at least 15 years ago. But for regular people, it's not uncommon at all for people to come into our office and say things like, well, we're here today because we want to avoid probate because my grandmother's estate's been stuck in probate for 5 years, 6 years, 3 years, 9 years. We can hear double-digit years sometimes for probates taking that long, just for regular people's estates to be administered and the assets transferred to the people who are entitled to them. Now, we can just lowball it. Let's say, for the sake of argument, let's say it's 2 years. That's about as quickly as you can really hope to get one done. And during that period of administration, whether it's 2 years like we'll use for our example, or some of the longer running ones, 10 years, or celebrities taking 20 years, during that period, all the assets have to be frozen. Because if you think about it, no one has proven to the court's satisfaction yet, until the very end of the process, that things are being handled appropriately. All right, so those kids or heirs or beneficiaries who might need to live in the house or get some of the assets, they're effectively locked out. The assets are on lockdown during the administration process. Okay, so we got a formal court proceeding held in Superior Court, takes a long time, freezes the assets. Here's another thing that makes probate so wonderful. It's a public proceeding. If you know somebody who died, your uncle, your next door neighbor, and you want to find out every detail about their entire life history, it's all laid out there for the world to see in their probate file. All you have to do, they make it really easy. Well, COVID makes it a little bit harder, but you can't just walk into the clerk's office anymore, but you can make an appointment in there, go in to see the probate clerk, and say, hey, I'm here, I want to see my uncle's probate file. And they'll point you over to the computer and then say, okay, go look it up. You go, how do I find it? You go, well, what's his name? Write down the case number. Hand it to the records clerk. Say, hey, I want to see the probate file on this person. They will walk into the back, they will pull that physical file out, and they'll let you sit there and scrutinize the file as long as you want. And in that file, you'll see a detailed inventory of every single thing that person owned, every dime they owed, the name, address, phone number of any beneficiary who's going to get anything, right down to the sterling silver knives and forks. And then the juicier stuff. Who's disinherited? Who has to pass a drug test? Who has theirs stretched out over 10 years? All the things that can really open up a window of insight into that decedent's personal affairs. All right, it's all out there for the world to see. It is a public proceeding. All right, so formal court proceeding, held in superior court, takes a long time, freezes the assets, makes everything public. All right, and then here's the capper. It costs a ton of money. All right, now how much? It's hard to say. You can't just say it's 3% of a decedent's estate. They have this statutory fee schedule that's set forth in the California Probate Code. It's kind of a downward ratcheting percentage scale. It goes something like 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and 1% of everything up to 10 million or something. So depending for a person, and the crazy part about this is it's based on the gross value of the decedent's assets, the fee calculation. All right. The fee that we're talking about here now, most people, is another myth. Many people have a belief that, the probate cost of probate is some kind of a tax or court cost goes to the government. It doesn't. The fee that is awarded through the probate code statutory fee structure, that goes to the lawyer who has been injected into this process, because the executor administrator, will or no will, is basically forced to enlist the assistance of a probate attorney. And these probate attorneys, all right, they're the ones that the fees go to. And they've rigged their fee calculation in a way so that the fees are based on the gross value of an asset. So if you have a house, for example, that's worth $600,000, but you have a $450,000 mortgage on it, most of us would view that as a $150,000 asset. For purposes of probate fees, the probate lawyer's fees, that is a $600,000 asset. And so this ratcheting scale, 4%, 3%, 2%, is based on the gross value of the decedent's assets.
So like in $1 million estate, it's like a typical $1 million estate, which is not what it used to be.
Right.
You own a home, maybe a few bank accounts. What are we looking at, a ballpark figure of the total cost of probate?
Gross value, okay, let's say, so we've got 4%, 3%, that's 7, then we have 8 twos, that's 16, right? That's $23,000
$23,000
for the lawyer,
right.
But then you got to double that because the executive administrator gets the same amount as set forth in the code. All right, so for $1 million estate gross, all right, you'd have $1 million house only with a $950,000 mortgage on it, and the probate costs are going to be $46,000. All right. It's crazy.
Maybe we should get into probate.
We like to we don't make fun of. We just like to take business away from the probate attorneys because we're all about avoiding it. All right. So here's now. We're going to play.
Real quick. I'm sorry.
Yeah.
We've got more people that signed up. We can tell how many people in the room. You can't tell, but we can. And so for those who entered late, there is a chat feature here as we go through this. If you have questions, fire away. They come to us directly. They're private. I just want to keep that in mind. This presentation is really about an interactive experience with you guys and us. So no one's taken advantage of the chat feature yet. Please do so. Okay,
yeah.
Continue.
Okay, so for you late arrivers, we're talking about probate today. And any discussion of probate is inevitably going to quickly devolve into what a horrible process it is and how it's essential to attempt and to, in fact, avoid it through proper estate planning. I've touched upon kind of a real quickie version of what makes probate so horrible. Formal court proceeding, held in superior court, got to have a lawyer. Okay, we talked about that briefly. Takes forever, a couple years, maybe way longer. Freezes all the assets during the period of administration, so kids or beneficiaries who might need to live in the house or locked out, and ends up costing a ton of money. And the shocking part about the costs associated with probate for many people is it's not going to the government. It's not a tax. It's a government system that's imposed upon unprepared people, but the government isn't really getting rich off it. You know, there's judges that are making full-time pay on it, but the government is not really the big benefactor in this. The probate attorneys are, because they've stacked the deck. They've rigged the system, and we see how one of the ways they've rigged it, number one, they are forced into the process. Number two, their fees that they have embedded in the probate code are built on gross asset values, not net. It's really kind of absurd that they got that one in because, as I just illustrated in our little example, $1 million estate. You got a house that's worth $1 million, but you owe $950,000 on it, and that's all you got. You die. The fees are going to be based on the $1 million asset, the gross asset value, not the $50,000 worth of equity that you had in that property. And so, in a case like that, $1 million estate, $46,000 probate fees. All right, and they got to come from somewhere. So that's the quickie as to what makes probate so horrible. Now we're going to play a little bad cop. I was a bad cop telling you how horrible it is. Now Chris's good cop routine. He's going to tell you.
But before we go, do you want to talk about the joint tenancy trap?
Oh, many people think they can be joint tenancy. Oh yeah.
So
all right. Okay. Lots of people say, all right, I can beat probate. I'm going to put beneficiaries on my bank account. Okay, that would work. I'm going to put a beneficiary on my stock account. That would work. I already have beneficiaries on my retirement account. Okay, but we got one big bottleneck. And this is often the tipping point between the determination as to whether a living trust is needed or not, which I'm starting to steal some of his thunder. Okay. But ownership of real property. Okay, we got the bank account covered. We got the stock account covered. The retirement accounts are already covered. And what we say is, okay, I'm going to beat this stupid probate thing. I'm going to put one of my kids on title to my house with me as a joint tenant. And then when I die, it'll flow to that kid. And then that kid is certainly going to share with his brothers and sisters.
Or married people do it even.
Right. Yeah, and married people will put kids on. It's insane for a whole lot of reasons. I don't have time to fully go into my parade of horribles on this thing. All right. We do that in our full-blown live presentation, which we condensed into our evening webinars that we referred to earlier. But no, for a whole lot of reasons, it is really, really bad legal advice that people usually get from their hairdresser or their H&R Block dude as to going ahead and adding joint tenants on a property with you. Number one, chances are that person will not end up sharing. Certainly a possibility. You might say, oh, my kids all get along great. They'll do the right thing. You've made it hard for that one child, if you did it that way, to even step up and do the right thing, because if they then are attempting to share with their siblings, they're going to run into our goofy gift tax rules, all right? And they will bear the brunt, the negative tax implication, if they have to give away what is then legally theirs. That's another disincentive for them to do it. And then even scarier than that, when you start adding people on as joint tenants, you're adding potential liabilities to your own property. All right. Let's say I put my kid on as a joint tenant so the house can pass to him after I die. And then he gets in a car wreck. The thing about joint tenancy that people don't understand is if I added his name to title as a joint tenant so it would flow to him after I pass, which it would, joint tenancy is that right of survivorship. And then he gets in the car wreck. He doesn't own half of that property. He owns 100% of it with a right of survivorship. All right. And if I've added all three of my kids, I've just tripled the chance of disaster, because if my daughter gets sued because she runs up some credit card debt, my son gets in a car wreck, and my other daughter gets divorced, I've now exposed my property, 100% of it, for each of their follies, okay, on the outside. So, and little kicker, joint tenancy titling, which is kind of the default form of ownership for married couples and others, leads to a really horrible tax outcome that we have an alternative to that is available through proper planning. So don't think you're going to beat probate by adding joint tenants to your home. You're giving them a bad tax outcome. You're asking for friction between family members because there's a chance the one that you added isn't going to share with the others, and you've exposed yourself to insane levels of risk over which you have no control. All right? So what's the right way to beat probate?
Before we get into that, I just want I alluded to the very beginning of Paul's discussion about joint tenancy, how it's a trap. And so let me explain how that works for married people. Like the typical married couple, when they purchase real estate these days, and this has been true forever, they take title as husband and wife as joint tenants. And that provides a certain peace of mind in their mind that, hey, if one of us dies, it's just going to flow naturally over to the survivor. But the problem is, where the trap lies, is that doesn't happen on the second death. And so when the surviving joint tenant dies, let's say husband dies first, and then years go by, wife does nothing because wife thinks they're protected because there was no problems at all on the husband's passing, and the property just transferred over naturally over to her. And she does no planning, and then she dies. Well, guess what's going to happen? Boom, probate. That's the trap, because it lulls people into thinking that they've got a plan when it really isn't a plan. It just delays the probate for, in the case of a married couple, until the second death. And so you've got lots of probates out there because of people who thought they were protected by simply taking title and joint tenancy. So it's not a solution whatsoever. It's a horrible solution. And so there's a far better way to protect your assets from probate and be able to dictate what happens to them, and that's through a revocable living trust. Okay. Now, so we've made, and there's a question there. I think we can probably
We'll get to that one.
We'll get to that one. Okay. So we've made available for download in the for a sample documents of all the documents that we normally produce as part of a typical estate plan. If you look at those, you'll see that the family trust is based upon the film The Godfather. I wanted to make the reading more interesting for normal people. That's why I kind of built it on that, the trust around that movie. And so if you know it, you'll appreciate what I did to some of the characters in there. But the point is that in that sample that we made available for document is a trust. And so you can take a look at that and see basically what a trust looks like. And so what does a trust do? Well, basically, you set it up while you're alive. That's why it's called living, because it's created while you're alive. And it's revocable because you can change or amend it anytime you want. So if a married couple sets up a revocable living trust, they can change it or amend it before they die, and the same with a single person. So it's revocable and amendable while you're alive. It's set up while you're alive, hence revocable living trust. Now, here's the distinction. A will, regardless, is going to go through probate. Now, there is an exception in very small estates where there's a slightly abridged version of a probate procedure, and that threshold, it's a bright line, is $166,250. So anybody who owns real estate in California, if they don't have a living trust, they're destined to go through probate. And so what a living trust basically does is allows you to set up a vehicle in place while you're alive that you will transfer assets to. And you're going to designate in that trust who's going to be the initial managers of that trust. So in the case of a husband and wife, the husband and wife are going to be the managers. So they're going to wear all the hats when a trust is established. They're going to be the people who create the trust. They're going to be the current trustees of the trust. And ultimately, they're going to be the current beneficiaries of the trust. The distinction between a will and a trust is that a trust survives your demise. It continues to operate like an entity after your death. And so because it's still in existence legally, it survives the probate process. You do not need to probate a living trust. If you transfer assets into your living trust, when you die, if you're single, or if the second spouse dies, if you're married, those assets are going to pass on to your beneficiaries without having to go through probate, because that trust is still going to be around to do that. And the trustee who you designate, and when you do a will, that person is called an executor. But when you do a trust, that person is called a successor trustee. The successor trustee's responsibility is to implement the trust. It is not at that point when you die, if you're married, both spouses are dead, or if you're single, the trust is irrevocable. So while it's revocable while you're alive, once the creator or creators of the trust die, it becomes irrevocable. And that person you designate, your successor trustee, his job is to implement that trust. It's that simple. It's set in stone at that point. This is handled privately within the family. There's no need to have any court involvement whatsoever. And if the trust says divide the assets of the trust equally amongst the kids, that's the trustee's job. They cannot deviate from that whatsoever.
Kids or whoever.
Right.
Because we did get a question that comes in that said, do we need a trust? We have home, we have assets, but we don't have any kids. Well, yes, you do. The short answer is yes, but the deeper answer on that is that's a tough topic. For our clients that don't have kids, the planning becomes a lot harder. Who are you going to put in charge and who are you going to leave to? The two core elements of one's plan become a little bit more, tougher to contemplate. But if you're thinking about, okay, we don't have kids, so we're going to leave it to our brothers or sisters or nieces or nephews or something, you still do not want to subject them to the nightmare that is probate. Okay?
Correct.
So it's really the asset mix that you have, especially including real estate. And then it's just if you elect to try to not put somebody through a really horrible process in the course of the distribution of your assets after you die. Now, it's easy for a lot of clients that don't have kids to say, well, I don't really care as much as I would if I had kids. I want to make it smooth to my kids, but I don't have kids. Oh, well. So that's your prerogative. But there's another aspect of estate planning that is the secondary objective that we're not going to have time to get into today. But that's protecting yourself. If you don't die, you're 100% certain you're going to die, but you got a chance you may become incapacitated before you die. And in a case like that, you need the proper estate planning documents to avoid the court process known as conservatorship. Okay, but that's a topic for another day.
Yeah, that's a whole separate webinar.
Right.
But
Go ahead.
For those who are not married, who are married and have no kids, and we get this occasionally, or a single person has no kids, and like, I don't care, I'm going to be dead. That may be true. But you do care if you get sick. And so, and we're not going to get into the intricate details of conservatorship, but if you get sick, and there's a roughly 50% chance that you will cross the line and need someone to help you, if you don't designate in writing who manages your finances and who makes medical decisions for you, you're going to go to court to get those jobs appointed. And that's called conservatorship. So those who are married and have an estate that would go through probate, you still want to do a living trust and all the other documents that we do as part of a typical estate plan, because you want to protect against incapacity. And so for that reason alone, you should consider doing a living trust. So let me summarize again what a trust really is. It's really, if you think about it, there's two things that it covers: who's in charge of what and when, and who gets what and when. That's what this paperwork that we put together for people when we're doing planning is planning for, those basically two areas: who's in charge of it and who gets it. So when the trust context, when you set up a trust, the trustees are in charge of the assets. The initial trustee would be the person who creates the trust. And then when that person dies or becomes incapacitated, then the transfer of power would occur to the successor trustee, who you would appoint, not a judge, who would take over and manage the trust assets. Now, if you're alive, their job would be to manage them on your behalf. And that's their job, because you can't do it yourself. And when you die, and only after you die, or if the second spouse, if you're married, dies, then the assets can be distributed to the beneficiaries free of probate. And so the who gets what part is covered in the context of the living trust. So you're going to dictate who's in charge of the assets, and then you're going to dictate where they ultimately go. And the reason why a trust, again, avoids probate, because that trust is going to survive your demise. It's still in existence, and it's the vehicle which provides the transition of assets from the trust to the beneficiaries. That's done privately within the family. There's no need to go to court. It's that simple.
Yeah, and here's the thing too, what he said, and it's easy to have it just go right over. When you designate that successor trustee, and the second spouse, or you, if you're single, passes away, that successor trustee is empowered by the preordained arrangement you've set up, that transition of authority that you've preordained in your estate planning documents, to be in charge of the assets. Contrast that with the joint tenancy trap we talked about, where, okay, I'm going to leave everything to this kid and then hope that kid spreads it around to the others. It's 180 degrees different than that. You are not leaving the assets to that successor trustee. You are designating that successor trustee has legal authority over those assets to figure out what you had, gain control, pay your bills, and then do a little accounting to prove to his brothers and sisters that he wasn't stealing from them, and then make the distributions. You're not leaving it to him or her. You're putting them in charge of the process. Okay, big distinction.
Yeah, and then one of the common misconceptions about when you set up a living trust is there's somehow a loss of control, that I'm establishing something and I've lost control of my assets. I don't own them anymore. And technically it's true when you have a living trust, you're transferring title, and we'll get into how that's done in a minute, to the trust. And so the trust is going to be the owner of the assets. However, you are going to instill yourself as the trustee, which means you are the exclusive manager of the assets. And you can do anything you want with the assets once they're in the trust. You can buy, you can sell, you can open accounts, you can close accounts. You are in charge of your destiny. You run your affairs just like you would do before the trust was established. The only difference is you'll see that, like with, for example, with real estate, there'll be the deed will be put into the name of the trust, so your title will change. Those are subtle reminders of the trust's existence. But as far as your day-to-day stuff, you basically run your life the same way you did as before the trust existed. The trust owns the assets, but you are free to do anything you want with those assets. You don't need to ask permission from the beneficiaries. So that's a very important distinction. So a living trust is yours to control as long as you're alive and you have your wits about you. And so you can do anything you want. And so that's a common mistake, that people think that somehow they're losing control when they establish a living trust. Another common area where people think it's trust only for rich people. Well, Paul talked about the threshold for probate. If you own real estate in California, I wouldn't, owning a home wouldn't necessarily classify you as rich. So with a home without a trust, it's going to go through probate. So trusts are for everybody who has an estate large enough to trigger a probate, and those thresholds are very low. Okay, so but a trust itself without any assets in it is basically worthless. It's just a piece of paper. And so a trust has to be funded for it to do its magic. And so what does that take? How do you fund a trust? Well, some of the stuff, when we do a living trust for our clients, we take on the responsibility of funding when it comes to real estate, because we have to transfer ownership of your home into your trust. Otherwise, it's going to go through probate, even though you have a trust. So that takes a deed, and that has to be done correctly. And so we prepare those deeds and we get those recorded for our clients. And by transferring your home, for example, into your trust, you're still going to be on title as the trustees of your trust. But because that home is titled in the name of the trust, it avoids probate. It's that simple. And so that would be true of any other real estate that you own. So it takes a deed to transfer ownership of your home or any other real estate into your trust. And we do that. Now, there's bank accounts that you have, and there's brokerage accounts that you may have. And if you have those accounts and you don't have a designated beneficiary on those accounts, they're going to go through probate. So we want to transfer ownership of those assets into the trust also. And so we design our trust that you are free to do that yourself and don't have to continually change or update your trust every time you open a new bank account or close bank account. And so we're going to give you a document that you can use to basically fund the trust yourself when it comes to assets like bank accounts or brokerage accounts. And so in that sample documents, there's a document called a Certificate of Trustee Authority and Power. And that document is designed so that if you went to a bank and said, I have a living trust and I want to transfer my bank account to my trust, and the bank person says, let me see the trust, you're going to show them that certificate. And the reason why is we don't want to disclose to the bank, because it's none of their business, who ultimately is going to get the trust assets. Remember, the living trust is private. There's no court involvement. So we don't want to share the intricate details of how we want to distribute our estate with third parties like banks. And so we give you a tool that's called the Certificate of Trust that you can take to the bank and show the bank officer, here's who's in charge. It says who are the successors. And you need to know this information, but you don't need to know the private deeds stuff in there about where it ultimately goes. And so that document gives you the power to go to the bank and put that account into the trust. And if you close that bank, you can close that bank. You don't need to amend your trust because the trust is not going to say or itemize all the different assets that you own. It's going to give you the power to go on a go-forward basis to choose to do banking business, whatever bank you want to do. And all you got to remember is to put that account into your trust, and that's all it takes. And so you don't have to worry about amending your documents if you happen to close a bank account or buy another piece of real estate. And that's important. There's only two reasons why you should ever consider changing your trust if it's done correctly, and that's to change the trustees or to change the plan of distribution. Those are the only two valid reasons really why you would need to amend the trust.
Right.
Okay.
So in addition, we get a second category of asset in your trust for you. As Chris said, we take care of the real property by way of deeds. We prepare the deed, you sign it, you pick your pen up off the paper, that property's in your trust. Then we got to get it to the recorder and the assessor, and they do their little sniff tests on it, and they can't reassess. They cannot increase your property taxes by this type of transfer. The second is your personal property, your stuff, your cars, your furniture, your TV, your grandpa's shotgun, collectibles. All your personal property is assigned into the trust by virtue of that document that is in those samples too. It's called the comprehensive transfer document. So we take care of the real property, we take care of the personal property, then you hit the pavement, you go out to the banks, you talk to your stockbroker, you have them transfer those accounts into the trust, and that's how we complete that process known as funding the trust. That's the follow-up steps. See, we always tell people, hey, you're coming in to sign, congratulations, but don't blow out your rotator cuff patting yourself on the back. You're not finished yet. We both have some follow-up work. There's really important follow-up work involved in this process known as funding the trust after the documents have been completed, getting the assets positioned correctly so that the trust can work its magic when it's called upon to later on.
Yeah, and so you can have someone, you may have heard stories of someone having a living trust and they still have a probate proceeding. And why is that? Well, the reason is, let's, for example, that you do the living trust and then years go by and you just completely forget about its existence. And that does happen, believe it or not, because life gets in the way. And then you buy another piece of real estate and you don't put it into your trust. Now, that's a big mistake because what's going to happen if that real estate's not titled in the name of the trust, it's going to go through probate in order to pass on to your beneficiaries. And so we don't want to make mistakes like that because mistakes like that lead to probates, even though you have a living trust. Same can be true of bank accounts. And so we build in another document It's actually a will, believe it or not, that we put together as part of when we do a living trust. It's a special kind of will called a pour-over will. It's designed to capture those mistakes should you make them and leave the assets to the trust. So it says, look to the trust to figure out where assets ultimately go. So it's called a pour-over will because it's designed to take assets that are not in the trust and leave them, pour them into the trust for the purposes of determining who gets them. But we never want to use the will. The will, as you know, goes through probate. And so if you own a piece of real estate and it's not in the living trust and your pour-over will leaves it to the living trust, it's going to have to go through a full probate in order to get to that living trust.
It's a safety net.
It is.
Exactly. Use safety nets. Okay?
So
you got it, but let's not use it.
So, the plan of distribution is set forth in the living trust. All the will is going to say, a pour-over will is going to say is, whatever I don't have that's in the trust, I leave to my trust for the purposes of figuring out who gets it. Again, a safety net is designed to protect against those mistakes because you still get to dictate the outcome because your trust is going to say who ultimately gets things, but it's going to go through a probate if the mistake is large enough. So again, the threshold, any real estate or any other bank accounts that are over $166,000 will trigger a full probate. So we don't want to put ourselves in a position to have to use that pour-over will. But it's better to have a will that says, go look to the trust to figure out where it goes than leaving it up to the California probate code, who will dictate in the laws what they call intestate succession, which means dying without a will dictate where your stuff will go if you don't plan around it. So even though you may have a living trust, without that pour-over will, you potentially can have the California rules applied to the who gets what stuff. And so that's why we do the pour-over will, so we don't let that outcome happen, because that's a disaster potentially, especially if you're treating kids unequally, or you're just inheriting a child, or you're including in your plan of distribution maybe non-children like grandchildren or other more distant family members and friends. That's not who is going to get it under the California will and the probate code. So we don't want to use that at all. That's why we do the pour-over will, to guard against mistakes and so that you can ultimately control the outcome if you make a mistake. But remember, funding is critical, and we don't want to ever have that will see the light of day.
All right, let's shift gears for a second and address a couple questions that have come in that kind of have to do with, okay, the inference is, okay, I get it, probate's horrible. Let's say we set up a trust, and let's say our parents, for example, set up a living trust, did everything right, got their assets transferred into it, sequentially, eventually they pass on, and then one of us kids is the successor trustee of the trust. A couple questions have come in that are dealing with the post-mortem administration of trusts. One has to do with if there was a loan. Okay, Christina sent this one in. It says, what happens if the decedent had a loan? Does the bank get notified the person died and can call the loan due?
That's true of either probate or non-probate context.
Right, and this is in either context, but and this is a good question with several layers to it. Typically speaking, when a decedent dies with a mortgage on their house, for example, that lender, as long as they're getting paid by whoever has authority over assets at the time after following death, the successor trustee or executor, I guess, of a will, as long as they're getting paid, they're not going to start turning over rocks. Nobody formally notifies that lender unless somebody foolishly notifies them. And so if they start receiving checks for the monthly mortgage payment from a different person than who had typically sent them, they don't really care. They're going to let it, that can proceed status quo for a while. Eventually, it's going to need to get addressed. And if the house gets sold, well, then the lender is going to get paid and it's over. If kids want to inherit that house and hold on to the house and then deal with the lender, there are provisions that allow for an assumption of a loan by inheriting children. Some lenders might make you go through a refi process, many won't. All right, so there is no formal notification. The only people that get notified of one's death typically is Social Security.
Well, yeah, you do need to notify Social Security immediately. But here's how it can happen, even though you don't intend to notify the bank. Because a lot of people, like when we're dealing with the successor trustee, whether it's a spouse or a child, they're worried about what do we do about the mortgage? And when you bank with the same institution sometimes, and you update the records to reflect that person with the checking account has passed, they may tell the other department, the loan department, that there's been a death, and that could trigger a due on sale. That's basically, if you look at your real estate paperwork, if you read your promissory note, you'd see that the bank has a right to call the note if you die. And that's scary, and that puts a lot of pressure on the family who are trying to determine what to do with that house. Maybe there's a lot of stuff inside the house that has to be dealt with. And the last thing we want is pressure being applied by the bank because they're trying to call the note. So we typically advise people to just continue making the mortgage payments. And then when you know what you're capable of doing, whether you can assume the loan or refi around it, or you're going to sell the property, then you let the bank know, and they'll work with you to get you to the point. They'll give you a flexibility to get to a point where they're ultimately going to get paid because they've got that lien. They've recorded the lien. That's the mortgage. And so regardless of what happens, they're protected. So, but they do have the power to call the note. So you got to be careful, and you have to finesse that properly because you don't want a situation where the bank is putting undue pressure on the family at a time when it's difficult to manage because of all the other things that are going on.
Well, and Christina's follow-up is no trust, asking for probate. Our experience has been that reverse mortgage lenders are somewhat aggressive. Okay, they're going to give you 90 days and nothing more.
So most can give you up to a year. I've seen that, but again,
it varies by lender, and it's up to your ability to negotiate with that lender. And if there is no trust, then the question becomes, well, who's got the legal status to negotiate with the bank? Well, that's going to be whoever the court appoints as the decedent's administrator, and that takes time. Especially with COVID right now, the courts are just starting to come out of their backlog. In various counties, like we know now, if you file a probate petition in LA County right now, it's mid-September, you're probably going to get like a December hearing date. I mean, they're really pushed pretty far out there. So that doesn't help your process of dealing with a lender if you don't have the legal authority, because the lender's going to say, well, who are you? You don't have the right to discuss this person's loan with me until the court appoints you as the administrator or executor of the decedent's estate. So that can be a little hiccup too, just getting over that hurdle of who's got the right to negotiate loan extensions or assumptions or refinancing or whatever with the lender.
So let me answer Mary's question about her father having a trust and then she needs a tax ID number. So assuming that your father was single and he had a single trust, when he passed, yes, that trust would now need a tax ID number, and here's why. The social security number of the person who creates the trust goes away when they pass. And so while they're alive, it's a pass-through entity. The IRS treats the living trust as a pass-through entity as far as the creator is concerned. And so they disregard it for the purposes of income tax purposes. And so you're going to continue, if you set up a living trust, whether you're married or single, filing your tax returns the same way you did before you had a trust, because it's passed through. The IRS disregards it. But once you die and that trust becomes irrevocable, the reason why you need a tax ID number is because the banks, if you have a bank account, for example, in the name of the trust, they need to report the interest income to a number, and that social security number no longer exists. So they'll ask you, you need a tax ID number, and without a tax ID number, the successor trustee is not going to be able to step in there and perform business on behalf of the trust. So once someone dies, then it becomes an irrevocable trust. That's the point in which the requirement to have a tax ID number is triggered. And so that's the distinction.
And for that transition of authority over that bank account, the example Chris is using, as we said before, the transition of authority has been preordained in the trust documents from the trustor trustee, your dad, to the successor trustee, maybe you. And in that case, what it takes are three things really for that successor trustee to walk into a bank and properly assert their authority over that account, and then have the bank recognize them as the person who has legal authority and control over that bank account, can write checks or whatnot. And those three things are basically death certificate, tax ID number, and trust documentation that shows that you are in fact the successor trustee, right? And so once you get those things, you unlock those accounts, and then you're up and running on the accounts as the controller, not the owner of those accounts.
So I mean, our practice, just to talk in general terms, we do planning, which is the preparation of living trusts and other documents. And that's a big part of what we do, but we've been doing this for a very long time. I'm over 30 years, he's over 30 years of practice, and we've got a lot of clients, and some of our clients do occasionally die. It's a fact of life. And so our practice also consists of helping successor trustees handle the administration side of things. Now, unlike probate, where you absolutely need an attorney to go through the probate process, you technically don't need an attorney to administer a trust. But we often find when successor trustees, whether it's the kids or some other person calls our office on behalf of the person who died and says, what do I do now? We can help them through that process. And so it's a part of what we do is the trust administration stuff.
Well, there's parts of it that are somewhat technical.
Yeah.
Like if you're a successor trustee, you need to know that when you finish the process, you don't have to keep looking over your shoulder, waiting for one of your siblings to claim foul that they got cheated out of something 5 years down the line. So there are number one, transparency mechanisms that need to be put into place so that all the beneficiaries know what they're entitled to get and that you're the right person to be in charge and everything. And then there's backside covering that is critical for that trustee to know as well, that when they go through this process and adhere to the formalities that are imposed, and the California Probate Code, ironically, is also the law that governs trust administrations. So we look to the code for some of the things that we must comply with in terms of carrying out one's trust, assurance of the transparency of it. And it's that transparency when the beneficiaries have all been afforded the opportunity to see the documents, know what they're entitled to receive, know that's what mom and dad wanted. Well, then that makes it transparent. And then that basically self-polices. There are no trust police that come in and say, okay, somebody died, now let's get this trust going. But the beneficiaries self-police it because they know that they were supposed to get their, 1/3 share. Well, 1/3 of what? Now the trustee has to produce that accounting that says, here's what we started with, here's what I spent money on paying bills, and now here's what's left, and that's what we're going to divide into our shares. And so the beneficiaries have rights that a trustee must recognize and comply with the formalities so that those rights are honored.
Okay, and keep the questions coming. Christina has asked a follow-up question. What if there is no trust? We're talking about a situation where there's a loan on the property, there's no living trust, person dies, bank wants to get paid, no one's doing anything, maybe because the house is upside down or maybe there's not enough equity to do anything. What can the bank do in order to collect on that note? Well, they can actually open up a probate. Creditors have a right to start a probate, even if the family refuses to do so. And so in a situation where there's a loan on the property and the bank is not getting paid, and if there's no probate open, they have a right to open up a probate for the sole purpose of foreclosing and getting that house sold so they can get paid. So banks have the right to start a probate even when the family doesn't want to do it.
Yeah, so keep the questions coming, you guys.
We're about 13 minutes to the noon. we want to go a full hour, and so we'll filibuster a little bit. So let's just talk about big picture stuff. The reason why we wanted to do a webinar on probate is because probate is probably when people think about estate planning and what can be done to avoid it and protect our families, probate is one of the things that they think of. It's the thing that jumps out there is like, we got to avoid probate because everybody's heard the horror stories. And so to summarize, with a living trust, you can eliminate the need for probate completely. You can keep everything private within your family so that when you pass, the assets will transfer to your family free of any court involvement whatsoever.
But it's important to note too, it's not the living trust in and of itself that accomplishes that. It's the living trust as part of what we call a comprehensive integrated estate plan, because basically what we've talked about up until this point to help us avoid probate on our assets when we die are really 4 documents. We touched upon the living trust, that's called the Declaration of Trust. We touched upon the comprehensive transfer document. That's the mechanism by which you assign all your personal property that you own today or ever go buy in the future. Like you go buy a new TV, it's automatically going to be a part of your trust. Then we've got the Certificate of Trustee Authority and Power that Chris referenced. That's the document that you take around and show financial institutions to enable you to transact business so that you're not always updating your trust, chasing your tail, but allowing you out there to transact business without revealing the personal drama, which might be revealed by the way the money flows to your beneficiaries. All right. And then the 4th document that helps us complete the beatdown of probate is the pour-over will. All right. And that's our safety net. Don't want to use it, but that's the 4th document. And those 4 working together, part of your comprehensive plan. That's really the only effective way to defeat probate.
So there are more documents involved in a typical estate plan, and that's really a subject for another webinar. Or if you want to, you can hit our website. The full-length version, which is the evening webinar, goes into every single one of those documents in more detail. We alluded to it earlier about the avoidance of conservatorship. That's a big part of this planning process too. And so there's other documents that are involved in a marital estate plan. or a single person's estate plan. So if you're interested in learning more, you can go to one of those webinars that are posted on our website, or you can just contact the office. Sure. And you can reach out to us, and Paul and I will be happy, whether that's through email or through a phone conference.
Plus, we do have a lot of content on our website that answers a lot of frequently asked questions about estate planning. Christina's got a follow-up question. You want to?
Sure. Okay. So you're asking about a situation where this is a hypothetical. Husband is on the loan. The property is jointly held. Let's say husband and wife is joint tenants, but the property's only in husband's name is the only one on the loan, and husband dies. What can the bank do? The bank can foreclose just like they could in any other situation. The person who died is no longer with us. It triggers a due on sale clause, and the bank can play hardball with the surviving spouse, and it can get really ugly. And so in that particular situation, you're going to want to finesse it and work with the bank to position them in such a way as not to put undue pressure on the surviving spouse. But yes, they have a right to call the loan. Let's see, what is there a second part?
She's asking about homeowners insurance. That's a pretty easy one. When we accomplish that funding component of transferring one's property into one's trust by preparing the deed, you sign, it's in. We often advise our clients, now you should contact your homeowner's insurance company and tell them that you have a trust and you want that trust added. And there's a little difference of opinion among insurance professionals about the proper terminology. We've heard people say, have the trust added as an additional insured, or I've had people correct me and tell me that it should technically be add as an additional loss payee. But either way, it's not a bad idea to let your homeowner's policy company know that you have a living trust and you would like the trust added to the policy in whichever jargon they prefer. And that's there to cover like a 1 in a bazillion chance that, a meteor hits your house, the house gets destroyed, you die. The insurance company owes you money, for your homeowners to replace your home. But since you're dead, their knee-jerk reaction is to make that check out to your estate, which is not a part of your trust. Okay, that's what the portable will is for, right? Pick it up and dump it into the trust, then it can go to the kids or whoever. The problem is that check is probably going to exceed the $166,000 threshold that Chris mentioned, and it could trigger a probate. Whereas if the trust had been recognized by the homeowner's policy, they could make that check payable not to your estate, but rather to your trust. Okay, so super low probability of needing that level of coverage or that nuance. But hey, while you're doing it, you might as well. Okay.
Jan, you've got an amazing question about your father owning 18 properties that he wants to split equally amongst the children. He better have a trust if he owns 18 properties. That's going to be one heck of a probate case, if not.
Sign me up.
So
the gross values of those 18.
If you can convince, if he's still alive and with you, if you can convince your father to do a living trust, you should pay for it, by the way, because the amount of money saved with 18 probates going through probate is going to be incredible. Let's assume that you can't get to your father, that he's not willing to do a living trust, doesn't believe in whatever the reason.
Lost capacity.
Whatever. And now we got a probate with 18 properties, and these are rental properties, and income's coming in. What's going to happen to that income? Well, ultimately, it's going to transfer to the kids after going through the full probate process, and the executor who was appointed is going to have an account or accounts that are in the name of the estate, and they were going to be able to collect those rents and hold on to that rental income until the probate concludes, unless you ask the judge for permission, and this is granted not very frequently, to make preliminary distributions. Because the judge doesn't like to do that typically. They want the assets to be retained in the estate, the income to be retained in the estate in case creditors show up out of the woodwork. And so they typically don't allow for preliminary distributions unless there's an emergency situation where there's children that need money for care and surviving spouses that need money for care. There is a way to get some allocations. Some money comes out of the probate before it concludes. But in most cases, it's not the case. And you're going to have a situation where that income is going to accumulate in an account until the probate's closed. And then the executor is going to just split the estate up.
But I think the question is also specific that says, hey, if this child is supposed to receive that property, can the rental income generated by that property be allocated specifically to that particular child at the termination of the probate? Yeah, that can happen.
The answer is yes, it can.
For sure.
Net income, not
Yeah.
the gross.
Right. Another problem, though, that we didn't touch upon, if somebody has a lot of assets in their probate, and if you're referencing your dad's will, and so we're talking about this estate with all these properties going through a probate, the courts impose a bond very often. Even if the will says no bond, they will often impose a bond on that administrator or executor of the estate. And that bond amount is going to be determined by the gross value of the probate estate. And so that could be extremely high, which, number one, the executor administrator has to qualify. They have to be creditworthy and able to, in order to have a bond issued to them. And that premium on that bond can be really pricey if you're talking about a high net worth probate estate. And so that's another expense that just gets flushed down the drain in the course of a probate as well. And it's just another barrier that the court puts up, because the court wants assurance that the administrator executor isn't going to run away with all the assets that are under the control. It's kind of an old-fashioned thing, but the judges have been known, especially in higher net worth probate matters, to impose a bond even if the will says no bond required.
Just another expense, another reason to avoid probate.
Mm-hmm.
You know, you've got filing fees, you got the bond fees, you got to pay a probate referee. In the case, for example, with 18 properties, that probate referee has to go out and appraise all 18 of those properties. There's expenses associated with that. So, you know, it's a no-brainer when it comes to doing the math analysis between what the cost of doing a living trust is versus what the cost of going through probate. It's really, it's not close. It's absolutely no debate. The trust wins hands down.
Well, there's also way more flexibility you can achieve in terms of your trust, because the exact issue that you're raising now, okay, we have these properties allocated to these different kids. We want to make sure that after I pass, that the revenue from each of those properties stays linked to that property, so that the revenue that had been generated in that period after my death, but before those properties can be distributed, which is obviously much quicker through a trust than through a probate as well. So there isn't that accumulation going on to the same extent that there would be in a probate. But absolutely, you can say all proceeds associated with this property go to the individual that property is to earmark to be going to. So just the ability to draft way more flexible and customized provisions in one's trust is generally hands down another reason why they're so far superior to wills, which are generally very cursory and vague and skip dealing with issues like what you're asking about.
Okay, so Christina has a question that comes up a lot, and whether you're doing a trust or not, you have a beneficiary, a child beneficiary, for example, that's getting Social Security disability, or maybe even Medi-Cal. Those programs are means-based. In other words, they look at your assets. There's an asset test you must satisfy in order to qualify to get those benefits. And so if you leave someone who's getting, for example, Social Security disability or Medi-Cal a bunch of money upon death, whether that money is coming from a trust or coming from a will or coming from an estate that has no trust or will, it's going to trigger the loss of those benefits, because those benefits are based upon the assets of the individual receiving the recipients. And if they receive big inheritance, then that's going to knock them off of those benefit programs, and they potentially can lose them for forever, depending on the amount of assets received. And so there's a way that can be done. There's a way to leave money to anybody who's got the need to have, Social Security disability or Medi-Cal benefits continue, and that's called the special needs trust. Now, we do that kind of planning when we do the revocable living trust. We built that into the plan and we ask that question, do you have any children with special needs or circumstances, to flush that out, because it's a red flag and we plan around it. But if you have a situation where there is nothing in place, no special needs trust, that's what they're called when you set up a trust to allow that person to continue to receive government benefits. If there's no special needs trust in place, the only way you can do that is with a court order. So you can theoretically petition the probate judge within the confines of a probate proceeding and ask the judge to have the inheritance that would otherwise go to a beneficiary getting Medi-Cal or Social Security disability to be put into a special needs trust. That can be done. It adds cost and expense to the probate process, but it's up to the discretion of the judge to do that. So you don't want to put yourself at risk. If you have special needs beneficiaries, you want to address that head on in your estate plan.
Right. Another question coming in. How do attorneys get paid in probate? Not the fee structure, technically, but actually paid. Does it force a sale of property? How does it work? as we indicated before, during the administration of a probate, whether it takes 2 years or 15, assets are locked down. Beneficiaries don't get their shares, with rare exceptions like Chris was talking about for preliminary distributions, which are quite rare. Nobody gets paid until the end of the process. It is until everything's been handled appropriately by that judge and they're satisfied that it's been done appropriately. That at the end of the process, the scraps that are going to go to the beneficiaries trickle out the pipeline and the professionals get their fees. All right. And so the lawyers, the probate lawyers who are injected into that process, they wait until the end, but it is a part of that court's order at the final order for distribution that's issued by that court says, okay, here's how the assets are going to be divided. This much goes to this beneficiary, that property goes to that beneficiary, that property there, and here's the attorney's fees payable to this law firm. And that is a part of the order. And if there is not adequate liquidity in that estate, we're dealing with the $1 million house on a $950,000 mortgage on it, the lawyer's going to get paid. And if it has to force a sale, it forces a sale, because that's going to be a part of the court's order for distribution at the end of the process. So just when the beneficiaries get their share, the attorneys get their piece of the action. And if there's not liquidity ample in that estate, there's a house that wants to go to the kids, too bad. It's going to have to be sold so that the lawyer can get paid.
All right. Any more questions, guys, as we approach? Actually, we're past the noon hour.
We're actually in afternoon now, isn't it? We were talking about an afternoon webinar.
Yeah, well,
okay. Yeah.
Whatever. Okay.
Mountain Time. Anybody logging in from Mountain Time?
So we know there's still people out there in the audience. We're giving you a taste of what probate's all about and how to avoid it. It's tough in the confines of an hour presentation to really drill it down to all the nitpick level details of probate and how it works and how to avoid it. But hopefully we've given you a flavor of basically what it takes to avoid probate. And if you're interested in learning more, again, you can hit our website. We have other webinars about the subject matter. You can arrange for a phone conference with Paul or myself or an in-person appointment. We still see people. We practice social distancing.
We're doing that on Zoom now, so that's another option for getting in touch with us too. But yeah, so as we said, we got the full-blown evening workshops. I think we got one coming up next week, Wednesday, right? 23rd, I believe.
Yeah.
No. Today's the 23rd. I think it's the 1st, I believe. Yeah. It's on our website. I think it's next week, one evening. We do our long form webinar. And then our plan on it, daytime series will continue, I think, in a couple of weeks. Got another topic coming up as we referenced previously. Lots of resources on our website. Feel free to check that out periodically. We post blogs. We're writing commentary now about topics of interest. There's some good ones out there now. So feel free to stay in touch. We're here. If you have questions, don't hesitate to either check in with us one way or another.
Yeah, by the way, that interaction with us is not going to result in the bill. It's a free consultation.
Kind of wacky that way. We don't charge the talk.
Yeah, so yeah, if you reach out to us and say, I forgot to ask Chris or Paul this question during the webinar, or we ran out of time, whatever, I got distracted, and you send us a question like that or an email, we're not going to hit you up with a bill, I promise you. We only charge for work, not talking about work.
Right.
So there's no risk at all reaching out to us for further information. If you decide to hire us to help you with your estate planning, we would love that, but you're not obligated to do so. Okay?
All right. Well, thanks, guys. Thanks for hanging in. We appreciate it. And, you know how to find us. Okay.
Take care.
Thanks. Take care.